So let's turn now to recording and reporting cases. So the playbook also contains a short section reminding employees of their obligations for both reporting and recording work-related injuries to the appropriate authority, in this case, Cal OSHA. So let's begin with the recording requirement. The black letter law requires employers to record work-related fatalities, injuries, and illnesses. With this pandemic, this obligation has been expanded and can potentially include COVID-19 related fatalities or injuries. But what exactly must be recorded? As you can see on your screen, for an injury or fatality to be recordable, it must meet two elements. The first one is that it has to be a work-related illness, injury, or fatality, and it must result in one of these items in your screen. I want to point you quickly to the very last one, which says that if there is a significant injury or illness diagnosed by a physician or other licensed health professional, which COVID-19 would squarely fall within this definition. Now, while this may seem like a simple rule, employers must determine whether the injury, illness, or fatality is truly work-related. The California Code of Regulations require that employers consider an injury or illness to be work-related if an event or exposure happened in the work environment, and the injury or illness was caused or contributed to the resulting condition or significantly aggravated a pre-existing injury or illness. So employers must look at the work environment, which potentially includes the type of businesses that they operate, the employee's work duties, and among other factors, in determining whether the employee's exposure to COVID-19 was in fact due to the exposure to the company's work environment. Now, note that the law provides that work-relatedness is presumed for injuries and illnesses resulting from events or exposure occurring in the work environment. Also note that work environment includes not only the company's physical locations, but also the equipment or materials used by the employee during the course of his or her work. So if the company determines that the injury, illness, or fatality was work-related, how do employers record it? So if the employer makes this determination about a COVID-19 case, they must record the case on the corresponding OSHA forms or logs, such as the OSHA 300 log. Now, turning to reporting cases of COVID-19 to Cal OSHA. Not only are employers required to record them, but they also have to report them under certain circumstances. So employers have to record work-related injuries, but also report any serious illness, injury, or death of an employee that occur at work or in connection with work to Cal OSHA. For purposes of COVID-19, note that a serious illness may include those that require inpatient hospitalization beyond simple medical observation or diagnostic testing. Be mindful that the law imposes a timing requirement on employers for purposes of reporting these incidents to Cal OSHA. So time is of the essence here. Generally speaking, employers must report them to Cal OSHA within 8 hours of when the employer either knew or should have known of the illness, injury, or death. The regulations do carve out a narrow exception in those instances when the employer can show that exigent circumstances existed. But even then, employers must still report it to Cal OSHA no longer than 24 hours after the incident. Now, let's quickly run through some hypotheticals of when employers must report COVID-19 related illnesses to Cal OSHA for illustration purposes. So on example 1, the facts are employee A becomes ill while at work. Employee A is COVID-19 positive and is admitted as an inpatient at a hospital for 4 days. So what happens? The employer has to report this illness to Cal OSHA as it would be deemed an illness occurring in the place of employment. Now, example 2 is very similar and the facts are virtually the same as the previous one. Employee B becomes ill while at work. He is also COVID-19 positive and is admitted as an inpatient at a hospital for only 2 hours. What happens? So the result is virtually the same. The duration of the hospitalization is irrelevant for purposes of reporting. Turning to another example. Here, employee C, who is a waitress and whose work duties include dealing face-to-face with various customers on a regular basis. She begins developing COVID-19 symptoms outside of work and is hospitalized during non-working hours. So what happens in this scenario? Here, the employer must still report the illness to Cal OSHA even though the symptoms appear outside of work. The illness was presumably contracted in connection with employment. Now, in this slide, you can see what's taken directly from the Employee Playbook, and it lines up and describes the different regions that cover Cal OSHA, and it provides you with the contact information for the various Cal OSHA offices throughout the state.